Of both processes. I am running for election here, and I have been screened by the Governor's Committee as well. So I wouldn't feel comfortable saying I totally disagree with the CUI Commission, because that would be hypocritical. However, judges can be elected. I think what we have here is a very confusing array of people, and I can't say I'm totally against the committee or totally for it. So I guess that's all.
Thank you very much. This is wonderful for this many people to have this divergent of answers, and I think this really helps the audience separate out. If everybody had the exact same answer, it would be hard to decide who to vote for. So thank you very much. We're going to take a short break from the questioning. I want to introduce you to Greg Wursel. Attorney Wursel was the one whose actions made tonight's event possible. When Mr. Wursel ran as a candidate for the Minnesota Supreme Court back in 1996, he found that the canons of judicial conduct inhibited his First Amendment rights of free speech, and the United States Supreme Court agreed with him. Greg, I am proud to call you my friend, and I welcome you here this evening.
Because I'm sure you want to hear from the candidates and not from me, I'm going to try to make my comments short. First of all, I think it's wonderful that we've got, I counted 14 lawyers here running for this position. I know that actually 24 have filed. I want you to also understand, however, that we've still got a lot of work to do, because there are many judges running unopposed in this same judicial district. I think, are any of the incumbents opposed? One? Okay. And that tells us that there's still something very wrong with judicial elections. I just want to give you a short history. In the year 2002, I won the case in front of the U.S. Supreme Court. That established the right of judicial candidates to state their views on legal and political issues. If you can't talk about the law, my gosh, what's the purpose? What would you ever talk about when you ran for this office? I have no idea. I don't know how you would ever justify that rule, or how that rule would ever make sense to anyone. In 2005, I won another case in front of the 8th Circuit Court of Appeals, which struck down additional rules which prohibited judicial candidates from attending and speaking at political party gatherings, seeking political party endorsement, identifying themselves as a member of a political party, and personally soliciting campaign funds. At that point in time, we thought we had established a working election system in Minnesota, because candidates could raise money, state their views, get a party endorsement, and actually run for these offices. That was a little presumptuous, because you have to understand the hostility of the judiciary towards free and open elections. And they created yet one more rule, which was that judicial candidates could personally solicit campaign funds, but only if there were 20 or more people in the audience. Now, before they adopted this rule, which is an absurd rule again, I attended a hearing before the Minnesota Supreme Court and told them that this rule was going to be unconstitutional. It didn't really matter to them. I want you to understand how absurd the rule is. If I wanted to ask my spouse for money, it meant I was going to have to bring 19 more people into my home. Now you laugh, and so did the court when it finally got in front of a federal court. So absurd was the rule that after we started the litigation, the Minnesota Supreme Court must have been told by somebody, hey, there's no way we can justify this rule. They actually changed the part of the Code of Judicial Conduct so that candidates could ask their spouse, but you still couldn't ask other people unless you had 20 or more people. So you see, even they, again, they like to apply blanket laws. Now, the thing we need to attack yet, and I've started a separate lawsuit again this year, is that word incumbent. That word incumbent absolutely creates an unfair advantage for the incumbent judge. It shouldn't be on the ballot. It's not found in any other part of the ballot except the judicial elections. And the Minnesota Supreme Court had its opportunity to correct this just 2 years ago. 2 years ago, this issue was in front of the Minnesota Supreme Court. They could have done the right thing and gotten that word off the ballot, but they did not. So this year we started another federal lawsuit. I was just in front of the 8th Circuit Court of Appeals, I think it was 10 days ago. for a special hearing in St. Paul, and we're asking them to remove that word incumbent from the ballot. Ladies and gentlemen, we are this close to having real elections for judges in this state. I am overwhelmed that you are here and that we are taping this so that it can be shown to other citizens. What is critical is that the voter get the information they need so that they can make an intelligent choice when they go to vote. And to make that intelligent choice, the candidates have to be able to state their views on legal issues. The candidates are going to have to be able to raise money so that they can get a message out to the public. These things are obvious. They're obvious to you, they're obvious to me, they're not obvious, however, to your state Supreme Court. So I want you to remember that, because some of them are also up for election, and I'm actually running against one of them. Again, I want to thank you all for being here. I want to thank all the people who are participating, all the lawyers. Again, I think we're moving in the right direction, and please keep fighting for your right to vote. Whatever you do, don't let anyone take away your right to vote. The Qui Commission is an absolutely horrible idea. If it was ever adopted, the judges, for all practical purposes, would be unaccountable to the public. I want to thank you all tonight for the time to talk, and God bless you all.
Thank you, Mr. Wursel. We will now begin the fourth round. Hopefully I will do it right this time. I'm going to call 3 names at a time in order, and then I will ask the question, and you will have 1 minute to respond to this question. And this particular category of questions is called the Minnesota Judiciary. And the people I'm going to ask are Mr. Stebbins, Mr. Hansen, and Ms. Burchell. And the question is, despite a budget of over $300 million, statements have been made that our judicial branch does not have enough money. Do you have ideas for ways to reduce expenses and stretch the budget further? Mr. Stebbins.
Yes, the steps have been taken, or attempted steps have been taken by different judicial districts to try and take their existing budgets and stretch them out to the point where they can actually cover the services needed for the citizens of the state of Minnesota. You can call it what you want as far as the budget goes, but budget cuts in the different courts that I work in have severely hampered the court's ability to carry out justice. Early case management in many counties in this district is a way that judges have attempted to do this, or courts have attempted to do this. I've been involved in early case management committees, and I actually am have been appointed in, about 100 cases now as an early neutral evaluator to evaluate the cases before they go to the court, to give some evaluation of the case to the parties with hopes it'll settle it and cut down on the large caseload faced by the judges.
Thank you. Mr. Hansen.
There's an old saying, justice delayed is justice denied, and that rings very true in Minnesota. When a court system is underfunded, you have a problem of backload. I don't know if any of us here are former public defenders or not, but I know the public defenders a few years ago were cut drastically in their numbers of attorneys, and as a result, their caseloads are, I believe, over double the ABA recommended caseload for a public defender. And what happens is you get attorneys who are overwhelmed, you get judges who are overwhelmed, and you get a system that's overwhelmed. Now, part of that is fiscal responsibility in every single judge's chamber in the Minnesota Supreme Court and how the system is run, but it's also a responsibility of the legislature to fund the judiciary, and it's a two-way street. Both things need to happen in order for it to run smoothly.
Thank you. Ms. Burchell.
For those of us who are in the